Good morning, everyone. I'll call Commerce to order on this fine, chilly Tuesday. Just by way of housekeeping for folks on the committee and otherwise, we're hearing bills today and Thursday. We do not plan to do any executing on either of those days. On March the 4th, a week from today, we will exec all the FNs, and then on the 11th, everything else. So that's where we stand. So I want to welcome Senator Rosenwald and open the hearing on Senate Bill 169. Good morning, Senator. Tell us what you've got.
I'm happy to be here. For the record, I'm Cindy Rosenwald, and I have the honor to represent 2/3 of Nashua's wards. And I'm pleased to introduce Senate Bill 169, which will provide more information to individuals that are receiving workers' comp benefits. So as you guys all know, workers' comp benefits are weekly benefits paid pursuant to RSA 281A by an employer's insurance carrier that are intended to replace some portion of the lost wages of employees who have a work-related injury or illness. Typically, this is about 60% of the regular wage. Sometimes the employer pays more. When members receive their workers' comp benefit, the amount they receive normally includes a duplication of payment of wages, which the employer had been paying on a contingent basis, and the insurance carrier paying also. The employee subsequently owes this duplicated amount back to the employer. Additionally, in many cases, the employer continues to pay both the employer and the employee cost of voluntary withholdings and deductions, the employee portion of which is also eventually owed back to the employer by that employee. So employees that are out on workers' comp for an extended period of time often receive minimal communication from their employer. When they return, they're notified that they owe some amount back, and sometimes it's a significant amount of money. So having not been told what their obligations are, employees may have failed to plan for that due to lack of understanding or education on the subject. And in just one instance in Portsmouth, when an employee returned to work, they were told they owed the city over $18,000. This bill aims to eliminate these surprise owed payments by creating a system based more on transparency and routine communication between the employer and the employee so the employee can plan. And I want to stress that the bill does not shift any employee cost to any other party. It simply notifies the employee what they are anticipated to owe and what methods there might be to pay it back. So there are experts behind me who can answer questions, but I hope the committee will look favorably upon the bill.
Okay.
And now I'm going to have to take myself back to landfills.
Enjoy your committee. Thank you, Senator.
Thank you.
All right, Brian Rill from the firefighters is here. Good morning, Mr. Rill.
Morning, Mr. Chair and members of the committee. For the record, my name is Brian Rill. I'm the president of the Professional Firefighters of New Hampshire, and we represent approximately 2,000 active and retired firefighters across the state. I want to thank Senator Rosenwald for bringing forward this bill this morning. Quite honestly, she stole my thunder. She did a very nice job introducing it, so forgive me if I restate a couple of her points, but we did work with the senator on this language. And the reason that it's important anecdotally is across the state, we've run into this a number of times. Obviously, in this profession, we have a number of firefighters go out injured somewhat frequently. And unfortunately, some of those are long-term injuries or illnesses. What is happening that we found is that if I went to work today, and let's say I rolled my ankle, my department would send me home. They would continue to pay my salary and benefits until such time that my claim, which is pending from the insurance carrier, the workers' comp insurance carrier, until that is ruled upon. If that claim is then accepted and approved and paid, there is some duplication of that salary that the employer was paying for that period of time. So I would then get a check, a workers' comp indemnity check from the insurer. And again, there would be a duplication there. So upon my arrival back to work, my employer would notify me that I owe them a sum of money, which quite frankly, I would have expected that. But there is no way of knowing what that amount is based upon salary, deductions, taxes, all of these things. It is a notification that the employer already provides to the employee upon their arrival back to work. All we're looking to do in this bill is shift that notification up some period of time. We think it's a reasonable amount of time to say that within 30 days of a long-term injury, there needs to be a notification, and then every 30 days thereafter, a comprehensive breakdown of what the employee will owe when they arrive back to work, or if the employer deems it appropriate, a payment method that allows you to pay it prior to your return to work. And the senator hit the nail on the head when she said what this bill does not do is shift any cost burden from the employee to the employer. 100% of what the employee owes in withholdings or deductions or salary payments back to the employer, they will still owe. This bill does not change it at all. It is quite simply a notification and a transparency bill, and to improve communication between the employee and the employer. So with that, I'd be happy to entertain any questions.
Okay. Are there questions? Well, you did a great job. Between the two of you, I think we got it covered. Thank you,
Great.
Mr.
Thanks so
Roach.
much.
Appreciate it. Danielle Albert would like to speak as well. Good morning.
Good morning. My name is Danielle Albert. I'm the Deputy Commissioner of the New Hampshire Department of Labor. I'm here with the department's General Counsel Attorney John Garrigan. Thank you very much for having us today. The department is neutral on the bill. We have reviewed the language and would just highlight a couple of technical points that the department has relative to the language as it is proposed. The department understands, I believe a little more fully now from some of the prior testimony, but that the proposed language as it's drafted is providing a mechanism whereby employers who make or provide supplemental to pay to employees have to give certain types of notification to the employees who are receiving that supplemental pay while they're out on workers' compensation benefits. The department would note supplemental pay is not a defined term within the workers' compensation statute. We therefore understand that to mean something either in addition to or supplementing indemnity benefits, given that it's embedded within the workers' compensation provision regarding memorandum of payment, which talks about how reporting about indemnity benefits is made to the department. We therefore understand supplemental pay to mean perhaps a couple of different things. It could mean salary continuation in that the employer is continuing to pay the individual's earnings. It could also potentially mean that the employer is paying the difference between the 60% that the workers' compensation insurance carrier is paying in indemnity benefits and the injured worker's average weekly wage, that 40% difference. We would understand if this language went into effect that these notification provisions would apply to either scenario. The department would highlight and would note supplemental pay would be regarded, or we would be regarding that as a form of wages, meaning that it would be subject to wage an hour law, so RSA 275 as it relates to payment of wages, inclusive of notification about deductions related to payment of wages and record keeping related to payment of wages. RSA 275, particularly at Section 49, contains provisions that employers are already following regarding giving notice about withholdings. Those notifications are required to be provided every pay period. Requires that certain records of pay be kept for certain timeframes up to it's a period of 3 years. So in looking at enforcing, if enforcement were to become an issue for the department under this provision, the department would be looking at these forms of payment as wage payments, because that is what they would be. Given that, the department would suggest perhaps turning an eye towards RSA 275. The language as drafted is giving a 30-day period following the date of injury and then subsequent notice every 30 days. Employers would need to be mindful if that 30-day time frame stays, that if they are paying the supplemental pay, they are still going to be required to provide with the notification provisions regarding withholdings that are set forth under 275-49, which are more frequent than the 30-day period that's specified here. And with that, I'm happy to take any questions should there be any.
Okay, thank you. Any questions? Yes, Senator Fenton.
Thank you for being here and taking my question. What happens to the employer if they do not send out this notification? Are there repercussions?
Yes, that's an excellent question. So under we kind of call them the wage and hour laws, but under protective legislation, employers who don't comply with the stated requirements relative to providing notice, pay notice, keeping records as required relative to pay, providing the notifications or the required documentation about withholdings are subject in some instances to civil penalty.
Thank you.
Any other questions? All right, thank you very much. Appreciate it. Is there anyone who would like to speak on Senate Bill 169 who maybe didn't sign up? All right, seeing none, I will close the hearing on Senate Bill 169. And we will start with our next bill in 2 minutes.
You're on time until you get to that.
I know. We've already looked at it. 176 may not be that bad. I mean, yeah.
I got it.
All right, I'm going to open the hearing on Senate Bill 171, an act relative to required pay for remote work. And I would like to welcome Senator Ricciardi. Good morning.
Good morning, Mr. Chair and committee members. For the record, I'm Denise Ricciardi. I represent 13 towns from beautiful Bedford to beautiful Hinsdale. I'm here this morning to introduce Senate Bill 171. It is a forward-thinking measure designed to modernize labor laws by addressing the evolving nature of work. The bill clarifies that employees who work remotely are exempt from certain reporting time pay requirements that traditionally apply to in-person work. By doing so, Senate Bill 171 strikes a balance between supporting workforce flexibility and maintaining fair compensation, ultimately benefiting both employers and employees in New Hampshire's evolving job market.
All right, very good. Thank you, Senator. Appreciate it very much. Natch Grace from the BIA. Is he here? Yeah. Okay, yeah, he didn't indicate he was speaking. My mistake. Okay, let's bring the Department of Labor back. Mr. Garrigan, Ms. Albert. Good morning again.
Good morning, thank you. My name is John Garrigan. I am General Counsel at the Department of Labor. With me is Deputy Commissioner Danielle Albert. The department is neutral on this bill, as we are with all bills, but though we do have some notes on kind of what we see as the enforceability of this law. We'll note that physical location is not defined in this law. Typically speaking, when we look at our state laws and the federal labor laws, generally the place of work or the physical location is generally kind of wherever that work is being performed, whether that's at a brick and mortar employer location or at home or at some offsite location. We do see that there could be some confusion or discrepancy in the enforcement of this if the intent is to take teleworking, like working from home, like truly working from home out of the 2-hour minimum. The confusion could arise where if somebody is working at a place that is not an employer's physical location, but is some offsite. So say if you're a plumber and you're working at somebody's home, or if you're a tech support person and you're working at an office building that's not your office building, but it's a client's office building. So our recommendation would be if there could be some more clarification or specific guidance on what does physical location mean. That would aid both our enforceability of it and also set expectations, I think, for employers to help them comply with this. So happy to take any questions that you have.
Okay, questions? All right, seeing none. Thank you both. Appreciate your time this morning. Allison Milioto, is that correct? Okay. Very good, thank you. From Blue Lion. Hmm? No.
Oh, okay.
Good morning.
Microphone, if you could, please. Thank you.
Good morning, and thank you for having me. My name is Allison Milioto, and I'm co-founder of Blue Lion, an HR consulting firm based out of New Hampshire. We have served hundreds of businesses and nonprofits here in the Granite State on matters related to HR, including payroll processing, policy creation, administration, as well as guidance related to compliance to regulations. Our team of over 14 HR professionals has a breadth of knowledge across many industries, as well as employer size and makeup. I am here today to voice my support for Senate Bill 171 and the proposed update to RSA 275-43-A regarding required pay. As a business owner and employer here in New Hampshire, I understand the importance of fair compensation for employees. However, the current interpretation of this law has created uncertainty and undue hardship for employers who are trying to comply. Each new director of the Department of Labor seems to bring a different interpretation, making compliance a moving target. This inconsistency is unfair to both employers and employees. The proposed update provides a much-needed clarity, specifically to ensure that employees who work remotely and perform brief tasks, such as answering emails on a Saturday for 30 minutes, are not entitled to 2 hours of pay. This aligns with modern work practices and prevents an unintended financial burden on the business. In my last 10 years of working in HR and operations, it was imperative to look at not just the letter of law, but also the spirit and its intent. For those 10 years, I, and most of my HR colleagues, interpreted the 2-hour minimum regulation to ensure employees who made the effort to ready themselves and commute to work did not incur greater burden or cost than they were to receive in compensation from their employer. I interpret it as protection for employees in all industries, in industries like hospitality, from being scheduled to come in for a shift as a server, only to arrive to work, potentially arranging for childcare, having the cost of gas or a bus ticket, or in today, maybe an Uber drive, from being sent home immediately because the employer was slow. It was also to provide a protective net for employees that their efforts to travel to work were not made in vain. In a post-COVID era, where 1 in 3 employees in a typical office setting now work entirely remotely or hybrid, this law needs to be amended to consider this aspect of today's work-life balance. Today, employees are able to work from home and balance a slew of Zoom meetings, emails, projects, Slack and Google Chats, and also have the ability to change the laundry, start the crock pot, or take a lunch that allows them to work out on their Peloton without having to commute to a gym to be able to focus on their health. I think the interpretation of the law needs to be clarified and documented for remote workers, removing any ambiguity or confusion. And if an employee wants to log in on a Sunday and get organized for Monday, checking emails and prioritizing their week for 30 minutes, the employer should not be held accountable for paying them for 2-hour minimum rule, nor should the employer have to be expected to reprimand that employee for going above and beyond without being asked. All legislation should be clearly defined, leaving no room for shifting interpretations that disrupt business operations. This bill ensures consistency, fairness, and clarity for all parties involved. I urge you to support this bill and provide New Hampshire employers with the legal clarity they need to operate fairly and effectively. Thank you for your time, and I open to any questions you may have. The last thing I do want to add, just in case you weren't aware, prior to our current director in the Department of Labor, the interpretation by Michelle Small was it was not for remote employees. So through their education in the state, where employers were allowed to come and get education from the Department of Labor, it was communicated it was not for remote employees.
Okay.
Now, fast forward, they've now shifted their interpretation of the regulation. So that's where the need for clarity is very important to us.
Okay, thank you very much. Questions? Senator McHugh?
Thank you, Mr. Chairman. Thank you, Ms. Miliotto, for coming and bringing your expertise. In the example, and for taking my question, in the example you gave, getting organized Sunday night for your week, can you give me an example of an employer who does pay a 2-hour minimum for the 30 minutes that somebody might take on a Sunday night, checking emails and prioritizing their week for 30 minutes?
So my understanding from speaking to the current director of the Department of Labor is we would be required to pay. So I personally operate a fully remote business. And when she came into office and I got wind that this was her interpretation, I had a physical phone call with her for that specific question, because my staff often will log in on a weekend. And her response to me was that I was required to pay them for 2 hours because they were doing work for my company.
So my question was, so could you give me an example of an employer who pays the 2-hour minimum? So you're using yourself as the example. So you pay your employees, or you somehow
I would
prevent
plead the
them, you
fifth.
lock them out of their
I will plead
computers
the
or something.
fifth at that question. My understanding is if I were to be audited, the expectation is that I do.
Ah, okay. Okay. All right. Any other questions? All right, seeing none. Thank you very much.
Thank you very much for your time.
Mike Summers from the NHLRA would like to speak. Good morning.
Good morning, Mr. Chairman, members of the committee. For the record, Mike Summers, President and CEO of the New Hampshire Lodging and Restaurant Association. We actually asked Senator Ricciardi to bring this bill forward, so thank you, Senator, for your work. Ultimately, the RSA 275-43A was really designed for employees that essentially committed some expense of their own in order to make it to work. A perfect example was used in the prior testimony as a restaurant scenario where an employee is scheduled to work. The employee comes into the building, is then told, look, we don't need you today. It's snowing, it's raining, whatever the problem might be. Power is out in the building. And then they're sent home. They're required to pay the 2 hours. In part, the prior person who testified outlined exactly the issue that has arisen for us, which is that once upon a time, remote work was not really subject to this, but now it has again become subject to this. And so this moving target becomes a problem, obviously, for businesses. So really what we are trying to get at is if an employee leaves home and invests money or expense of their own in order to make it to work, or at least on their way to work, then they should be compensated for that effort. If this person literally walks from their kitchen to the dining room and logs in, finds out they're not needed today and turns it off, probably not exactly the same level of expense. So really, that is what the attempt in this language is to do, is to recognize that when an employee really has nothing invested in it, that they should not be necessarily compensated for 2 hours, but yet that they should be paid for any time that they do work, whether that is, logging in and working for half an hour on a Sunday evening, so be it, then that should probably be compensated. But in the instance where they legitimately don't do any work, they shouldn't necessarily be compensated for that work. So that really is the effort. Obviously, we're here in support of this bill, and I'm happy to try to answer any questions.
Okay, thank you, Mr. Summers. Questions? Seeing none, appreciate your testimony.
Thank you.
Is there anyone else who would like to speak on Senate Bill 171? All right, seeing none, I'll close the hearing on Senate Bill 171. And in 4 minutes, we will start up with Senate Bill 177. All right, I'm going to open the hearing on Senate Bill 177, dealing with E-Verify. And we do not seem to have Senator Gannon with us, so, here we go. You've You've gotten a bit younger.
Just a little.
Good
Yeah.
morning.
Good morning,
And I see
Chairman.
you here, Joshua.
Thank you. Good morning. So for the record, I'm not Senator Gannon. Joshua Shower. I'm a legislative aide for Senator Gannon. So I'm just introducing SB 177, which simply requires New Hampshire businesses that have more than 25 employees to utilize the E-Verify system. So right now, about 23 states in the United States currently use it, whether it's subcontractors, contractors, or all federal employees. It's just comparing the I-9 to the E-Verify system and using it to match the verification whether or not you're supposed to be working in the United States legally. So if there's a mismatch with the I-9 form, E-Verify alerts the employer and the employee is allowed to work while resolving the problem for up to 8 days until they can get the problem situated. If not, then it's up to the employer. And E-Verify reduces the number of illegal immigrants in states that have mandated use of E-Verify for all employers. The program deters illegal immigration in the United States in general. Thank you.
All right, thank you. Very well done. Appreciate it. All right, next up, we have Representative Pam Brown. Good morning, Representative. How are you today? Doing fine, thanks. Microphone, if you could. Thank you.
Good morning, committee members. Representative Pam Brown, representing Kingston and East Kingston. I support the bill. I co-sponsored the bill. The unvetted immigration we've seen in recent years has been a key issue for my constituents. This bill simply requires New Hampshire employers with over 25 employees to use E-Verify to confirm their workers are lawfully in the United States. 10 states now require E-Verify for most employers, 8 more states require it for public employees, and several states authorize its limited use. Only 2 states, Illinois and California, outright ban E-Verify. The credit reporting company Experian explains that E-Verify allows employers to verify the employment authorization of employees to maintain a legal workforce and prevents the employment of unauthorized workers. It also, quote, matches the documents provided by prospective employees with records maintained by the Social Security Administration and DHS, which can help prevent document fraud and identity theft. Numbers USA, a nonprofit research organization, notes that U.S. Citizenship and Immigration Services provides the E-Verify system free of charge to employers and is available in all 50 states. They state that since several states have made its use mandatory, more than half of all new hires go through the system. Numbers USA concludes, quote, passing sensible E-Verify legislation is the single most important step state legislators can take to curb the hiring of illegal aliens who wish to compete for jobs with American workers. On their website, Numbers USA endorses New Hampshire's Senate Bill 177, which I believe is a common sense bill. Now, my specialty is education, and I'm an economist, but I'll take any questions.
All right, thank you. Are there any questions? Yes, Senator McHugh.
Thank you, Mr. Chairman. Thank you, Representative Brown, for coming and bringing your testimony and for co-sponsoring the bill. Would you say that the use of E-Verify, since it requires a social security number where the I-9 form doesn't, would you say that sort of levels the playing field in terms of protecting all the applicants and all the workers, making everyone have the same sort of requirements for eligibility?
Well, I did read the E-Verify website, and I noticed there were 2 different forms that could be completed, and E-Verify is one of them. It sounds like E-Verify is a little more stringent than the form that you just mentioned in requiring a social security number, yes.
So if I understand correctly, E-Verify requires a social security number and a photo ID, and the I-9 process doesn't necessarily require either. So if E-Verify is required, could you say that the use of E-Verify levels the playing field in terms of protecting all the workers and giving all the workers the the equal access or equal protection when it comes to applying for the same
Yes,
type of
exactly.
job.
Yes.
Thank you for taking my question.
Any other questions? All right, thank you. Appreciate your testimony. The Department of Labor is back.
Good morning again. John Garrigan, General Counsel for the Department of Labor. With me is Deputy Commissioner Danielle Albert. The department is neutral on this bill, though happy to provide some information and perhaps a technical suggestion as well. Right now, the department, we don't do anything with E-Verify. The department does, however, check employer records for I-9s or other proof of that the employers have assured the employee's eligibility to work, whether that is an I-9 form or copies of the required ID documentation under the I-9. The E-Verify, it's a totally voluntary process. Employers can do it. It's not a thing we check for. As written, this law, it does have a civil penalty structure to it. However, in a different law that we enforce that kind of acts like an umbrella, which is RSA 27311A, it requires generally the department provide a 30-day a warning and then 30 days to correct for violations of all the laws except very particular ones that are exempted. This bill as written does not exempt this from the warning procedure. If the intent of the bill was to exempt it from the warning procedure, we'd be happy to work with language on that. The existing provisions in RSA 275A for failure to have those I-9 forms actually is exempted from that warning procedure. The department can proceed with penalty without a warning or period to correct. So it's a thing we noticed. We're happy to work with the committee on that if that's where the committee wishes to go. But I'm happy to take questions.
Okay, thank you. Any questions? Yes, Senator Reardon. Okay.
Thank you, Mr. Chairman, and thank you for taking my question. So there's a provision in New Hampshire law already where you essentially audit the books of employers to make sure they've done I-9s.
Correct, yes.
Follow-up?
Yes, follow up.
Thank you. Is it a problem? Are you finding a lot of issues with I-9s in New Hampshire?
We do assess a lot of civil penalties for it. It's a fairly consistent problem.
So you're on top of it. Is it employers with less than 25 employees or generally larger employers?
The law, as it's written now, applies to all employers for the I-9 verification. This would, for the E-Verify part, this would just do 25 and more. So it would have two separate classes of employers.
Thank you.
Okay, Senator Fenton.
Thank you, and thank you for being here. Any concern? I see this as a huge burden on the Department of Labor. I mean, as of now, you're going to be responsible for investigating complaints, issuing subpoenas, maintaining a public database, and enforcing these penalties. Do you see you guys have the funds to do this?
Yes, thank you. It's a good question. My recollection was the department had done a fiscal note, and any sort of fiscal cost would be somewhat indeterminable. We believe under our current structure, given the way that our inspection division is currently comprised, and we also have a hearings bureau. So there is provision within this proposed language that requires that the commissioner shall hold a hearing in instances where it's determined it's not a fraudulent or unmeritorious complaint that's been filed. So we do have an existing hearings bureau that's staffed with hearings adjudicators to hear those types of cases. So at this juncture, it's our understanding or belief that it would be sufficient. We did not make note that any additional funding would be necessary or provide the cost calculator in relation to a fiscal note.
Thank you for that. My concern is there's going to be potential for abuse of this complaint system, and that might elevate your cases because this allows anonymous complaints, which could open the door for malicious or frivolous reports by competitors or disgruntled employees, things like that. Are you concerned about the elevated reports of this?
Yeah, I think that's a very good question. I mean, I'm not really certain how the department would go about predicting it. Certainly in instances where complaints, whether they're anonymous or otherwise in their sense, and at times having anonymous complaints such that individuals who may be nervous about bringing forward something of concern have a way of contacting a state agency and letting them know, hey, there's something going on here that appears to be not okay or out of line with what a statutory requirement is, I mean, it would require the department to assess and then to vet, as this language is laid out through the an investigation process, whether or not it's a frivolous complaint. To your point, that may potentially cause an increase in caseloads. I don't know at this juncture how the department would go about predicting what that number would look like or determining whether or not it would be of such a volume that it would require a lot of additional staffing or additional cost. I think it's too much of an unknown to be able to project at this juncture. You're welcome.
Senator Murphy.
Maybe I just don't know. Which RSA has your department auditing I-9s?
It is RSA 275A, and I believe it's section 4, and I'll look at Attorney Garrigan in case my memory is not serving me correctly. I believe that's the provision that sets forth the requirement for employers to obtain and maintain documentation demonstrating eligibility to work, of which an I-9 can do.
I found it right here. Thank you very much.
Excellent.
All right. Any other questions, Senator McHugh?
Thank you, Mr. Chairman. Thank you for bringing your expertise. So I'm hearing that you assess a lot of civil penalties on I-9, the current paper process. Would this electronic process potentially make it easier to access and audit and simplify that auditing process, maybe even eliminate some of those civil penalties and drive a little bit of compliance?
Yeah, it's an excellent question. So just by way of context, the department's engagement under current iteration of statute, the types of violations we tend to find as currently constructed, we do find that employers either have not maintained the documentation showing employee eligibility to work, or that said documentation is incomplete. Whether or not introduction of the E-Verify system would make that easier or lessen violations, I don't know that the department would be able to determine. Certainly, I think employers would need to somehow demonstrate that they have used E-Verify, either through some sort of printout. I believe there's a printout that comes out from the system once you've utilized it. That would be something that would need to be maintained, potentially to demonstrate or show compliance. But I'm not really certain how to project, or how the department would be able to project whether or not it would improve compliance.
If I could jump in quickly, I think to get to your question, I think this bill would not replace the I-9s in our role in that. It would be a supplemental process for employers with 25 or more employees. So we'd still be checking for them.
Correct for the question. I guess what I'm asking is, would this make it easier for you to check that they have verified employment eligibility, which is I think the crux of the issue?
I think the investigative process would be about the same. It would still require us to go to the employer to get their records to make sure that they have retained records of doing the check. So from an investigative end, it's about the same.
Okay. All right. Any other questions? All right. Thank you both. Appreciate it.
Thank you.
Blue Lion Consulting would like to speak. Welcome back.
And I did pass in my testimony again as well.
Okay.
Thank you again for your time today. As I already mentioned, my name is Allison Miliotto. I'm a co-founder of Blue Lion.
If I could, you don't need to read it if you just kind of want to summarize, since we have the written
fantastic.
documentation.
I love that for you, and I love that for me.
Okay.
We are opposed to this bill. We represent a lot of small employers of the 25 plus category in the state of New Hampshire. Some of the things I'll highlight is it is an increased administrative burden. So while E-Verify may be a free system, there's still an administrative cost to administering it. As the Department of Labor just mentioned, I still have to do a paper I-9. Then I got to transfer the information into a system. I also am now entering in someone's private information into an electronic system in which there's obviously the ability to have breach. You are now susceptible to security risks. E-Verify is not a perfect system, so it does sometimes flag people for being not legal when they are legal. That also could cause you to make hiring decisions based on that information that you then can be sued for. So it also increases your ability for lawsuits. It makes it a longer onboarding process. E-Verify is not instant. And so if we're working through the system and I'm now delayed in hiring someone, they potentially could get employment somewhere else. The final thing I'll say that is not in my written testimony is that From my experience in this industry, working with small employers in many states, so we primarily work Massachusetts, Maine, and New Hampshire, if someone is employing an illegal immigrant, they know they're doing it. And they're either skipping the I-9, now they're going to skip the E-Verify. So by forcing someone to use E-Verify, you're not forcing what they're already forced to do. So the fact that it's now moving to electronic is not going to stop them from hiring someone that they already knew is electronic. If I hire John Smith, who is using somebody else's social security and documents to work in this country, John Smith is still going to pass E-Verify, and I'm still going to hire the individual that is not John Smith, thinking that he's John Smith. So unfortunately, in our opinion, this does not actually add a layer that is going to stop the people who know they're doing something wrong from doing it wrong. And it's not going to eliminate the people who are using other people's social and documentation to work in the country. We just think this is adding more undue hardship on smaller businesses and requiring them to put information out there that they should not have to be putting out there. Where, as the Department of Labor stated, the I-9 form is very easy to fill out. We do it on a regular basis. It captures all the necessary information and documentation to prove that the person is legal to work in the U.S.
Okay. All
I
right.
open to questions.
Senator McHugh.
Thank you, Mr. Chairman. Thank you once again for taking my question. Are there forged documents out there being used to satisfy the I-9?
Thank you for your question. I have personally, we don't work with clients.
Could there be?
Yeah.
Could forged documents be used?
There absolutely is. And it's not necessarily even forged documents. What we've seen, and I can actually reference to a time back when I was in college and I worked at a restaurant, there was 3 people in the kitchen who used the same social. So they essentially, one person gets their documentation and then Charlie goes and works at this company, Bob goes and works at this company, and they're all called John Smith.
Would E-Verify catch that?
No. It won't, because John Smith is legally allowed to work in the country, and these individuals, because they're often related, do look very similar to each other. So they're brothers, nephews, cousins, uncles, aunts, nieces, not to discriminate. They often look like each other, so the documents, by the naked eye, look like this is the person who's applying. And E-Verify would say, yes, John Smith is allowed to work in the United States, but what you actually have in front of you is not John Smith working, but you think they're John Smith.
But thank you. That's okay.
Yeah.
Senator Fett?
So I just want to clarify and follow up. What I'm hearing is that, essentially this is an unfunded mandate for small businesses with a fee of $10,000 if they do not comply with a system that doesn't even work right.
E-Verify will verify that the person's information, thank you for your question. The person's information to which you are entering is legally allowed to work. Yes, it will do that. It cannot tell you that the human being physically standing in front of you is tied to the paperwork in which you have in your hand. That electronic system cannot do that. In fact, the Department of Labor auditing your files also can't do that. They would have to be essentially found by ICE, fingerprinted. I mean, it's very hard if the person looks like the person for someone to verify that they're not the person.
Thank you. Okay. Senator Murphy.
That's a question, just a quick comment. It's very nice to have somebody here who actually has employees to represent exactly real world scenarios. So thank you very much.
Yes, thank you for having me.
Anything further? All right, seeing none, thank you for your
time.
testimony. Is there anyone else who would like to speak on Senate Bill 177? We did have one person sign up in opposition. Oh, please. Thank you. Good morning.
Oh, good morning. Thank you, Mr. Chair, members of the committee. Hadn't planned on speaking. I'm, excuse me, Peggy Gilmore. I represent the Chamber of Commerce of Greater Nashua, has 430 plus minus businesses of all sizes. I won't speak to the pros and cons of using the E-Verify system, but one of the things that concerns the chamber and the chamber members is when there is a state mandate placed upon employers. If employers want to use the E-Verify system now, they can. It is an option that they have. So I think they would respectfully ask that when there is a system in place that is not considerably broken, that we do have those checks and balances, and we have an option for more. Let us be to do our business our own way.
All right. Thank you. Any questions? Seeing none, appreciate your testimony. Thank you very much. Is there anyone else who would like to speak on Senate Bill 177? All right, I will close the hearing on Senate Bill 177. We will commence with 176 in just a couple minutes. Oh, I'm sure. We had some working clothes at the inn years ago. Yeah, I was looking at the room. I'm like, there's not that many people. And only one person is speaking. Hmm? I don't. Mhm. Yeah. We could do that. I don't know that we need it because they've got to do an I-9 form now. And the I-9 has all that stuff on it.
If it's not. Like if you.
Ask him if the I-9 covers it. Because they turn on the numbers. Yeah. Yeah, and we try to anticipate which are going to be the biggest and we might be. Me too. All right, we will open the hearing on Senate Bill 176. It's my pleasure to welcome Senator Altshuler. Good morning.
Good morning. Good morning, committee. Good morning, Mr. Chair. This is a treat. I have never been before this committee before.
Well, welcome.
Yeah.
We're glad to have you.
For the record, my name is Senator Deborah Altshuler. I represent the seacoast towns of Exeter, Stratham, Greenland Rye, Hampton, Northampton, and Hampton Falls in District 24. Senate Bill, I'm a little out of breath because I just ran from the other building introducing a bill at 10 o'clock. So
Well, take a moment. We're just
Yeah,
fine
no,
on
we're good.
time.
Senate Bill 176 is a proposal to establish a minimum wage and gradually raise it from the current default rate of $7.25 an hour to $12 an hour by September 1st of 2025, and then again on July 1st of 2026 to $15 an hour. To offer some context on the history of the federal minimum wage, on September 1st of 1997, the United States minimum wage was $15.15 an hour. On July 24th of 2027, it was at $5.85 per hour. And this is the beginning of a gradual rise, which brought us to $6.55 an hour in 2008, and then capping at $7.25 in 2009, and there has been no change since. New Hampshire should consider establishing a state minimum wage above the federal level for the following reasons. New Hampshire, the economic security and living costs. New Hampshire's cost of living is significantly higher than many states that rely on the federal minimum wage. Housing costs in New Hampshire have risen dramatically, with median rent for a two-bedroom apartment requiring far more than $7.25 an hour can provide. Basic necessities like food, transportation, and healthcare in New Hampshire require higher wages for basic economic security. There is the benefit of local economy benefits and workforce retention. Higher wages increase consumer spending in our local businesses, produces a reduced reliance on public assistance programs. There is a lower employee turnover rate, and that reduces business training and hiring costs. The gradual implementation allows businesses to adapt over time, and our neighboring states, which particularly affects my district, all have higher minimum wages, creating competitive pressure. To the south of my district, and as a reference, I know that in New Hampshire, everything's 20 minutes away. Everything's 20 minutes away, minimum 20 minutes. It takes 20 minutes to basically get anywhere. And in my district, within 20 minutes, I can be in Massachusetts, and not just at the border, but well into it, or I can be into Maine in 20 minutes. It takes us a little longer to get to Vermont, but Massachusetts has a $15 per hour minimum, and Maine is at $14.65. For my colleagues on the western part of the state, for whom they can be well into Vermont in 20 minutes, the minimum wage in Vermont is $14.01. New Hampshire risks becoming a regional outlier without its own standard. Cross-border employment competition affects border communities, and it increases our challenges in retaining younger workers. Higher wages prevent workforce exodus to neighboring states and help local businesses with nearby states for labor. Invariably, the argument that businesses with smaller profit margins cannot afford a rise in labor costs, potentially impacting consumers. And respectfully, one has to wonder how the small businesses directly over the borders, 20 minutes away, into Massachusetts, Maine, and Vermont, stay functioning. Indeed, this argument assumes that New Hampshire businesses depend on exploitive labor practices that keep their employees in poverty wages, which in turn downshifts the meeting of basic needs to taxpayers through social services to those taxpayers. And we know that that is not the New Hampshire way. We have an opportunity to do something that benefits Granite State workers and raise the wage. I respectfully ask the committee to embrace this opportunity with a recommendation of ought to pass for Senate Bill 176.
Okay.
And if you want to exec it right now with that ought to pass,
Thank you, Senator. We'll be
that would
execing
make
on,
the morning.
we'll be execing on the 4th and the 11th, but not today. But thank you. All right. Are there any
You
questions?
can't blame a gal for trying.
No, not at all. Any questions for Senator Altshuler? Yes, Senator Ricciardi.
Good morning. Thank you for being here.
Good morning.
I just, the market forces are really the most efficient way of setting wage rates. And I know that we've done a pretty good job in New Hampshire. I don't know anybody getting minimum wage. I was at the mall not that long ago, and a little business in the food court had a sign, and they were looking to hire for $20 an hour. And so I think we're doing pretty good here.
Okay.
Thank you.
All right. Senator Finn.
I don't know what the question is.
I have a question. Thank you, Mr. Chair. You talked about the other states that have raised the minimum wage, and they seem to be doing just fine. And I guess my comment is, I see this as, there could be predatory business practices where employees cannot fight for their own wage and they're not, educated enough to figure out how to get a higher wage. Do you see that as a problem as well?
But we know that to be true. And what we see in businesses that are on the border states is that Massachusetts has a $15 minimum per hour. So we're at $7.25 because we default. We don't have a minimum wage. We have a default wage. And while there is a hope in deferring to market forces, what we know is that when we defer to market forces, which are profit-driven, that does not benefit the lowest of the paid workers in our communities, which is why we had to establish a minimum wage in the at the federal level in the first place. If market forces took care of everybody in the financial equation, we wouldn't need this. But that is not how market forces play out in the market. There are people who do the work, and it is the practice of business owners to look for labor as cheaply as they can. So if they can pay $12 an hour, $12.50 an hour in my community, and my community is unable, because of transportation issues, to get to where that same job pays $15, it's really an unfair practice. And I'm talking about some of the larger grocery stores that have spaces right over the border, and they pay vastly different wages. I am talking about hardware stores that have spaces right over the border that pay vastly different wages. I'm talking about Walmart, their distribution center that in New Hampshire, in a New Hampshire eye, looks like a fairly decent wage out of Raymond. You get paid to do the same exact job very, very much better over the border in Massachusetts. So I'm just looking for our chance to raise the wage, to create a space for our lowest paid workers to start a little bit further ahead than they are now.
Yep. Any other questions, Senator Murphy?
As an employer, I can tell you that my lowest paid employee makes $16.50 an hour, wash dishes. He's a 16-year-old kid in high school. And so I've been in the legislature a number of years. I've heard this bill or some variation of this bill a dozen times. And I'm waiting for someone to come up and say, I make minimum wage. Someone who isn't either a tipped employee or who is in an internship or in some other way receiving additional compensation other than financial. So obviously we have a list of people. Hopefully we're gonna hear from someone. I really want to meet that person who's making $7.25 an hour. I've yet to meet this person in all these years. Do you have anyone here with you today? Do you think that is going to be in that condition?
I personally did not bring anyone who's making $7.25 an hour. And also, would that change your mind about paying people for the labor that they're giving? I'm glad that you pay 16. That's above what I'm proposing. So if you're willing to pay 16, which is above this minimum, then it really shouldn't be a big leap to make other employers meet you where you are, because you're providing the example of where we're trying to go. So, I would challenge the business owners who are perhaps not in favor of this to look to your business as an example of it can be done, and it can be done here in New Hampshire.
Other questions? All right, seeing none, thank you for your testimony. Appreciate it.
Thank you very much.
David,
And I am no reflection on my commitment to this bill, but I'm also now running back to a different committee. So
understand.
scheduling is scheduling. I'm sorry. Thank you so much.
Thank you. David Trumbull is here and would like to speak. I think you were here last year for this too.
Yes, I was.
Good morning, sir.
Good morning,
Nice to see
Mr.
you.
Chairman. My name is David Trumbull. I'm from the town of Ware. I support this bill for a few reasons. First of all, I think it's a question of economic dignity to provide people with a wage that is far above $7.25 an hour. At that rate, if you work 60 hours a week, you would only make $22,000 a year. New Hampshire is clearly out of touch with the rest of the United States. It's not just a New England thing. This year, 23 states are raising their minimum wage. Missouri, by a huge margin of 58% at the polls, voted to raise theirs. It's now up to $13.75, and next year will go to $15. So Missouri's way ahead of us on this. As for where's the person who makes $7.50 an hour, the thing is that there are tens of thousands of people who make between $7.50 an hour and $15 an hour, and there's tens of thousands more who make just a little bit above $15 an hour who would be affected by this bill, and they would all be benefited from it. There was a recent report in Public Service News, a study done by Oxfam America, that said that if you raise the minimum wage in New Hampshire, to New Hampshire, there's 130,000 New Hampshire workers who would benefit from it. It includes more than 20% of women in the state who earn less than $17 an hour, and they make up the bulk of the state's child care and elder care workforce. So these are essential to our economy. You know that other economies, other businesses can't run without childcare because their workers can't come to work. 20% of women in the state make less than $17 an hour. So when you go to the grocery store tonight, and you see hundreds of people in there shopping before the next big snowstorm, and of all the women, 1 in every 5 there are making less than $17 an hour. Also, I would ask you to think about the question of food insecurity. Food Bank, New Hampshire Food Bank just said that 10% of New Hampshire residents, including 13% of our children, experience food insecurity. That means when people don't know where their next meal is coming from. And that's a 43% increase over last year. So what's the link to the minimum wage? Researchers from the University of California and Georgia Institute of Technology did a report called Raising the Minimum Wage Improves Nutrition Among Food Insecure Households. And they said that a 6.6% increase in the minimum wage, that's 50 cents, would increase the calories purchased by 3%, with those households most in need also buying healthier calories. So that's just 50 cents an hour. You have, how many did I just say? People who are insecure in the state, 135,000. That's a lot. 13% of children don't have enough food. Their moms are working in childcare and elder care. They can barely afford to put gas in the car and have a place to live. If you raise the minimum wage, 1 in every 5 women in the state is going to be benefited. Even the ones who make $16 an hour are going to benefit, because I'm an employer, just like you are, Senator. You have to pay a little bit more for your experienced workers, the people you want to retain on your job role. So if everybody's going to make 15, the person who's been with you for 2 or 3 or 4 or 5 years is going to make a little more. So this bill would not just help that person who makes $7.50 an hour, it would bring up the whole bottom of the wage role in New Hampshire. Now you might say, well, what role does the government have in doing this? Why not just leave it to the free market? The government is always impacting the economy. We just got rid of the interest and dividends tax. Almost all of the benefits from that go to the highest incomes. This is your opportunity to say, you know what? We know we make decisions that affect people's lives, their pocketbooks. We just helped the richest people in the state. It's your turn now to say to that 1 in every 5 women in that grocery store you see, say, we're going to help you out just as well, too. I'll leave you with one other thing, which is the question of jobs. They did a study, this is from the Center for American Progress in 2023. They compared states that follow the federal minimum wage and those that have a higher federal than that. From 2021, January, through May of 2023, that's 2.5 years, the states with a minimum wage higher than the federal level experienced a 38% industry-wide growth, double that of the states using the federal minimum wage, which was only 19%. And they also said this means job growth. So it was explained by Senator Altshuler, when people make money, they spend that money. These folks who work at the jobs that are getting paid $14, $15, $16 an hour, they're spending their money locally. They're not investing it offshore in 403s or buying yachts. They're spending it in their home communities. That spurs more development. Henry Ford figured that out. He paid his workers a higher wage so they could buy his cars. We're just asking you to do the same thing. And the last thing is, it will actually help employers because it reduces turnover. I have some written testimony for you. There's a lot of studies that show this. When you pay a decent wage, workers don't quit. You don't have to train somebody over and over again. You keep higher productive workers. It just makes sense for us as a state to come out of the deep, deep past and say, everybody else is doing this. There's no reason for us to continue on this policy that just doesn't make sense. It's not fair, it's not equitable, and it certainly doesn't help our economy. So, thank you.
Thank you. Are there any questions? All right, thank you very much. Appreciate it. Reverend Gail Kinney would like to speak. Good morning, Reverend.
So, Mr. Chair and members of the committee, thank you for taking my testimony this morning. For the record, my name is Gail Kinney. I am a pastor with the New Hampshire United Church of Christ. The UCC, we're also known as the Congregationalists. The United Church of Christ is the largest Protestant denomination in New Hampshire. There are approximately 130 churches and in all parts of the state. And if there's not a UCC church in your community, there's one next door. And absolutely, some of your constituents are part of the United Church of Christ. So our denomination, as a matter of morality, 11 years ago, after New Hampshire had taken a minimum wage off the RSAs, off the books in New Hampshire, went on record as a whole denomination, speaking for the entirety of the church, on record imploring you to reinstate a minimum wage and to bring it to as close to a living wage as possible. So just a little bit of history. You know, over the years, I know you, those of you who have been around for a while have heard this bill before, and I certainly have for years and years. The history of a minimum wage was, despite what many people argue, was never, ever intended to be a training wage for kids or for the newest of employees. It was always intended from its inception to be a basic wage that was believed at the time that people needed in order to live. And so it was a floor below which, as a matter of public policy, an entity, a state or the nation should not go in order to ensure that every worker, particularly every full-time worker, could survive, could thrive, and could probably, you know, or possibly also help a child or more or their children to thrive in the community. So that was the history of what a minimum wage was intended to be. And after New Hampshire did away with its minimum wage, and so that we are tied to the federal wage, which is really not the New Hampshire way to have the feds tell us what to do. But we heard, you know, I've heard testimony repeatedly that from employers who say, we don't need a minimum wage in New Hampshire because the market works. And just as the distinguished senator here said, you pay even the dishwasher $16.50 an hour. So what it's important to understand is the minimum wage that's called for in this particular bill would not affect you. It would not affect every single employer who comes to you and says, we don't need this legislation because we already pay more. If they are already above what the legislation is calling for, this bill doesn't impact them, whether it's a restaurant or whether it's something else. If you're already well above what's called for in this particular bill. And so, you know, we hear also, the market works. We don't need to establish a base wage, a minimum wage as a matter of public policy because the market is already working. Well, the market works perhaps most of the time, but the purpose of this bill is a correction or as kind of a moral statement of the state that this is, we want to correct when the market isn't working. And the market isn't working. There are now, there are about 5,000 employees in the state of New Hampshire who earn, it's still at the 725. I can't get in deeply to find out what those numbers are, but my guess is that they're primarily tipped workers and probably tipped workers that are not working in high-end restaurants, but are working in local diners or something with a midweek shift. The people that are working Tuesday at 2 o'clock in the afternoon are probably just bringing in the basic because an employer, a restaurant employer is required to ensure that their worker goes home with at least the minimum if they're not making at least that through tips. So that's about 5,000 people, but there are about 10,000 people, primarily women, not teenagers, people over 20, primarily female, who are working or who make less than $10,000 an hour. And there are 19,000 people in New Hampshire, again, primarily women and primarily folks over 20 years of age, who are making less than $12 an hour. For those people, the market is not working and they're working full time and they are still living in poverty and absolute daily economic anxiety. So the purpose of this bill is just to say in the state of New Hampshire, when the market doesn't work, we want to correct it to ensure that people who are working full time and contributing to the state of New Hampshire, the nurses' aides, the people, the childcare workers, et cetera, are not relegated to a life of poverty when they were providing work for New Hampshire. So I implore you to understand that this is not going to hurt most employers, it's not going to impact most employers in the state. It's just in the places where the market doesn't work. The one final thing I will say is that if this were, we're not a referendum state, But if we were a referendum state, and if a minimum wage, raising it probably to $15 an hour, were put to referendum in New Hampshire, overwhelmingly it would pass. But because we don't have that kind of vehicle, we are dependent on you. And so again, for the churches, I implore you to think about doing, finding ought to pass, daring to find this ought to pass as a market correction just in those situations where the market is not working for the hardworking workers in the state of New Hampshire. So thank you.
Thank you. Are there any questions? All right, thank you very much. It looks like Claudia Estelle, is that correct?
That's correct.
All right, good morning.
Good morning. Thank you, Chairman and members of the committee, for hearing my testimony. I'm Claudia Estelle. I'm a member of the Economic Justice Ministry of the New Hampshire Conference of the United Church of Christ. As a person of faith, I believe that every worker deserves respect and a living wage for their labor so that they can provide basic needs for themselves and their families. That's food, clothing, housing, communication, transportation, medical care, and education. Notice it doesn't include savings or paying back student loans. The minimum wage was established in 1938 by President Franklin Roosevelt with the express purpose of it being a living wage. It was to allow workers to be able to support their families. And we've heard a lot about what the minimum wage is and how many workers in New Hampshire are earning that wage, so I won't repeat that, but I would draw your attention to a couple of things. One is I'm a retired high school teacher, so I know a lot of teenagers who worked after school, and I would say that at least half of them worked because they had to. Their parents expected them to, at a certain age, to be able to pay for their school supplies, for their extracurricular activities. I think we have the vision of teenagers as earning PIN money for fun things or saving for a car, but there are students whose families depend on them to be able to make the difference economically, if they're. And for some of them, they're even helping to pay the rent and the electric bill. But besides that, a lot of the people who are low-wage workers in the state are not just teenagers who are living at home and have that support system. They're adults who have dependents, and they are not making it. So I would draw your attention to two facts. One is the federal poverty level for an individual is $15,650. If you are earning only $7.25 an hour, even if you worked 40 hours a week, 52 weeks out of the year, you would be earning less than that. So it's a poverty wage. And that is also true at the $10 an hour wage for two people. Since a lot of workers also have a dependent, that puts them also in poverty. The MIT Living Wage Calculator sets the living wage for a single person in 2024 at just under $19 an hour in Coos County, at nearly $26 an hour in Rockingham County. And by the way, I did email this testimony to you, so you also have that. It should have it in your emails. And all the other counties fall in between there. But the point that I really want to make is that the living wage in New Hampshire is between 2.5 and 3.5 times the minimum wage, no matter which county you live in. So this bill is proposing two increases to raise the minimum wage to $15 an hour over 2 years. It's not a living wage now. And for those who've asked, I don't know anybody who is earning less than $15 an hour. Well, I do. I'm not going to tell you their names because I haven't been given their permission to do that. And in 2026, when it becomes $15 an hour, it will be even less of a living wage than it is now. There are 61,000 Granite Staters. That's about 10% of the workforce who earn less than $15 an hour, and this would be a beacon of hope for them. I don't think we understand the amount of stress that people who are not able to make it financially are living under. I'm not being sure if they can pay the rent, if they're going to be unhoused, if they can feed their families, if they are going to be able to manage an emergency expense because their car broke down. So we have in the state an economic divide. We have people who can make it and we have people who can't make it. And I really feel strongly that it's really important for us to raise everybody up. And all the Granite Staters are worthy of being able to live comfortable lives. I also have another issue. I think that there are some companies, larger companies, that rely on the fact that if they don't pay their workers enough, that those workers can go and get public assistance. And in my mind, that is asking us, the taxpayers, to subsidize business. And I don't think that that's appropriate either. That basically is everything that I wanted to say, but I urge you please to vote this bill ought to pass. Thank you.
Okay, thank you for your testimony. Are there any questions?
I have a quick question.
Yes, Senator Fenton.
Claudia, thank you for being here.
You're welcome.
And speaking to us. Looking at some of the testimony you provided, every state around us has a higher minimum wage than us. And Rome is not burning in those states. But what we're asking for is a modest increase, essentially to help those low-income individuals and people who can't advocate for themselves. I heard my colleague mention that he's an employer. I'm an employer as well. And I think a bad assumption we're making here is that every employee can advocate for themselves for a higher wage. When in reality, if we relied on those market forces, we wouldn't have the highest rate of homelessness in the country. And we're having individuals like that teenager who knows how to go into a business and negotiate for a higher salary, whereas they can't live on $7.25 and maybe they just accept the $7.25. Do you see this happening?
I don't know that I see it right now because at this point I'm mostly retired, but and I teach as an adjunct at community college, so I work with older adult students. But I remember the first time that I testified at any committee in the State House was at the Labor Committee probably 7 years ago, and I can't remember exactly what the bill was, but it related to wages and workers. And I thought, nobody's talking about the kids. And so I said, I was really concerned because I would have high school students who would go and work for a grocery store that had promised that they would only work 10 hours a week and that they would never work beyond 7 o'clock at night, et cetera. And then they would find themselves having to work 15 or 20 hours a week, that they would be closing certain nights. And they're young, they're inexperienced. I'm not sure that even as an experienced adult, I would necessarily have the courage to speak up to an employer for a job when I really need the job, because I don't want them to say, oh, it's my way or the highway. And some of those kids are in a really hard spot where they're trying to bring in money for their family. So they didn't advocate. They didn't know how to advocate for themselves to say, wait a minute, this isn't what we agreed to. The person who spoke after me was the assistant commissioner for labor, and he said that one of the highest numbers of questions that they get were from parents asking about what the labor laws were relating to teenagers, and that they were concerned that their kids were being possibly taken advantage of. You're welcome.
Any other questions? Seeing none, thank you for your testimony. Appreciate it very
Thank
much.
you.
Is there anyone else who would like to speak on Senate Bill 176? Yes, ma'am. Yeah, why not?
I didn't prepare a testimony for this one. Again, my name is Allison Miliotto. I represent Blue Line. We're an HR consulting company here in New Hampshire. I'm going to put in a neutral on this bill, but I just wanted to give you some clear facts in the marketplace that we're seeing in New Hampshire. So someone had mentioned all of the different minimum wages in our surrounding states of Massachusetts, Maine, Vermont. I would like also to point out that while they do have a higher minimum wage, most of our employers are paying those minimum wages, but they also have a state income tax, which I think needs to be taken into consideration. We're constantly, when we have people that were employers that we're helping to negotiate with potential employees, we're making sure that we express that while working in New Hampshire, you don't have those state income tax, which greatly affects the amount of money you're making. So 15 in Massachusetts is not the same as 15 in New Hampshire. The other thing I want to point out that I think is important is we are still in a competitive labor market. So our employers are having to compete for labor where unemployment rate in New Hampshire is 2.6. The unemployment rate in Massachusetts is 4.1. Unemployment rate in Maine is 3.2. Now Vermont unemployment is 2.4. So they're doing a little bit better than us, but I would say our unemployment, I do think speaks to the fact that people can be employed. It is still a competitive market. I do appreciate the opinion that there are people living in poverty. I'm just not sure this is the way to solve the problem. I also appreciate that there are some teenagers that do need to work to help support their families, but there are also teenagers that are working just for fun money. So I think having a blanketed approach to say that every person I employ, regardless of my industry, has to be paid a wage to support a family is not necessarily a true statement, because sometimes the worker I'm looking for is that young college or young high school kid that's not supporting a family. It's their money for beer and pizza. And so that's the type of worker I might be looking for. So to require me to pay a wage that they could support a family of 2 children isn't necessarily speak. However, I also would like to point out economics is economics. If we're raising the minimum wage for some of these positions that are not intended for someone who's supporting a family, that you're going to increase cost. So one of the prior testimonies was talking about childcare workers. Childcare cost in the state of New Hampshire is a very large problem. Increasing the wages of people that work there, whether right, wrong, or indifferent, is going to inevitably increase the cost of childcare. So I just think, again, neutral on the bill, but I think you need to take into consideration the ramifications of how the trickle effect works. And maybe this is part of a solution, but I think if it is part of a solution, it just as that. It needs to be part of a solution. It's not the solution to all of the problems we're facing.
Okay. Any questions? Senator Fenn.
Thank you, and thank you for taking my comment. I have this, I think it's a dangerous assumption to say that teenagers are looking for beer and pizza money.
No, I said some. I said I do appreciate there are absolutely children out there that are helping put food on the
Because
table.
there are families out there
100%.
working for their family.
Mhm.
They don't have an advocate because their parents are at home. And a lot of us are blessed where we have a parent to bounce ideas off of and ask them about salary ranges and what the taxation that comes out of that. So I just want to be careful when we're talking about, who benefits from this bill and who does not.
Correct. I would agree with you. All I was stating is, as an employer, that might not be the employee that I'm marketing to. And there are absolutely positions out there for everyone in the world. So I think that there are positions that are intended for the person who is not trying to use this job to supply for a family. That there are positions out there that are meant to supply for a family, and to require the person who has lower margins and the inability to support a family to now require them to have a position to support a family, I think is not always going to work. But I would agree with you.
Thank you. Any other questions?
I have a quick one.
Go ahead.
Thank you for taking my question. So do you think that if the minimum wage were to be raised, that it would maybe harm first-time young people that are trying to get a job because there would be more automation in order to save money, more technology used?
Thank you for your question. I didn't think about that. I don't necessarily think people are going to spend more dollars to increase in automation. I mean, we already have self-checkouts and those kind of things. I don't see a fully automated McDonald's like in Texas coming to New Hampshire. I don't think we're looking at those kind of things. I do think it's going to increase people looking for those jobs. So if now the starting wage everywhere is 16, where before if it was 12, it was intended for the high schooler who's not supporting his family, just wanted some extra money. Now it's up to 16. Now other people are going to be vying for those positions. So I think it's going to make it more competitive for the employees.
Thank you.
All right. I was one of those kids who had to work to support the family. but minimum wage was $1.85. So that's how old I am. I'm aging myself. I own it. I'm proud of it. All right. Thank you. Appreciate
Thank you for your time.
testimony. All right, I'm going to close the hearing on Senate Bill 176. Next up will be 172. Senator Prentice, I'm sorry we're running late.
Thank you, Chair Ennis. That's perfectly fine.
I try.
You know, and for the record, minimum wage was $3.65 when I was in high school.
So you're
So
younger
we're-
than me.
We're just off a little bit.
I remember when it went to 210. I was so excited.
I remember just getting my first paycheck and being so
Yeah.
excited.
Yeah.
It was $1.75.
Aaron, are we ready? All right. Going to open the
For
hearing on
TNT
Senate
job,
Bill
550.
172, and I welcome Senator Prentice, who seems to be recovered. Glad to have you with us.
Thank you very much, and thank you for your well wishes, Chair Ennis and members of Senate Commerce. For the record, my name is Suzanne Prentice, and I'm a state senator from District 5, representing 15 communities made up mostly of Grafton County, some wonderful communities in Sullivan County, and one in Merrimack County, the beautiful town of New London. I am with you today to introduce Senate Bill 172, and this is what I'm proposing here is amending RSA 326B45. And so RSA 326, just to set the floor, is the Nurse Practice Act. But this particular section of the Nurse Practice Act, what it does is it renders non-compete clause, non-compete provisions unenforceable. But it only makes them unenforceable as it stands right now for nurses. But I'm going to speak to you about our advanced practice registered nurses, which I'm going to, just for the rest of the my introduction, refer to as nurse practitioners, because that's the others is a mouthful, and I've got some folks here with me today. So I'll be able to tell you why I think that we need to do this. First and most importantly, nurse practitioners play a significant role in providing healthcare in the state and primary care in particular. New Hampshire is not unlike other states, not just in New England, but throughout the country, that are facing shortages with primary care providers. And our nurse practitioners have played a role in closing, but not narrowing that gap, but not completely closing it. Primary care providers are important to access to healthcare and to really the health of Granite Staters because they are our traffic cops. When you go to your primary care provider, they know you, they know your medical history, you need, because of, whether it's because of your insurance is dictating that you need a referral from your PCP to certain kind of specialist. If you get stopped without access, you have to wait multiple weeks. It's going to impact your ability to get the treatment that you need. So this is like not new. If you look back at the last 4 years, I've been working with the nurse practitioners to bring about advances either in this act or in other places so that we can provide them with the protections and enhance their workforce to build out our primary care capabilities. So this is one piece of it, and I'll tell you why it's important. Again, RSA 326B45 now has non-compete language, making it unenforceable for nurses, but not for our nurse practitioners. So this is a very narrow change, and what we know is that nurses and nurse practitioners each have to carry, a nurse practitioner has to carry a license to be an RN, and they have to carry a license to be a nurse practitioner. So if the law is vague on this, then which license are they practicing under at that time, and which coverage do they have? If we want to support mobility, free market, and access to healthcare, having non-competes in place, we know is something that, in the nursing community has been, has that battle has been fought and been won, that we don't want to have those as a barrier to access. But here what we want to do is clean up this language so there's no ambiguity, that we're providing the protection that we need for our nurse practitioners. So if they have a job as an RN and they're practicing under that RN license, they're protected by the current statute. But if they are practicing as a nurse practitioner, then they are currently not covered. And one other point for clarification, in the definitions under 326, nurse does cover, there's a definition of nurse, and it does cover nurse practitioners, but it is not linked over to this particular non-compete clause. So again, looking to clean it up, no ambiguity, whatever license you're practicing under, you are covered as a nurse. The nurses already are. We just want to cover these nurses that are also working as nurse practitioners or nurse practitioners independently. I want to thank you for your time and consideration of this and all the good work you're doing for Granite Staters today and every day. And thank you. I do feel better, but water is good.
Everybody seems to be getting it, so, but glad
Yes.
you're back. So, are there any questions for the senator? Very clearly and concisely presented. Thank you for that.
Every once in a while.
Every once in a while.
I do have some members of the New Hampshire Nurse Practitioners
Yes.
Association that are going to be here.
They
I
are
won't be able
next.
to stay for all of their testimony because I've got to get back to Senate
Yeah,
Education.
that's fine.
But I trust if you have questions.
I will reach out. We will reach out.
Thank you so much. Thank
Appreciate
you.
All right, Kim Mohan is here from the New Hampshire Nurse Practitioner Association. I'd like to welcome you this morning. Good morning. If you could turn your microphone on and introduce yourself.
We'll start there.
Yes.
Kim Mohan, Executive Director with the New Hampshire Nurse Practitioner Association. I thought that instead of repeating what Senator Prentice has already shared with us, that maybe I would just be available to answer questions. I also wanted to share with you guys a one pager that I just handed to the staff to hand to you, but it just sort of is a nice infographic of
He went to make copies, I think.
and there were plenty of copies.
Oh, all right. Yeah.
Do-
Aaron?
Sorry, I don't know. I
No
just want-
worries. No worries.
in the interest of time, I know you guys are running behind, but I just
No,
wanted
we're
to share this a little
Take
bit
your
with
time.
you. Thank you.
Yeah.
Just share this a little bit with you. So, as Senator Prentice mentioned, we in New Hampshire we have a large umbrella of APRNs, right? So it's Advanced Practice Registered Nurses, and under that umbrella, there's a large portion who do serve as nurse practitioners. But I want to be really careful here and remind everybody. You can look at the little circle in the center. It's a good look at it. So we have the nurse practitioners. We also have the certified registered nurse anesthesiologists, the certified nurse midwives, and the certified nurse nurse specialists. This bill would cover all of those pieces. So everybody licensed under an APRN. And what we do have in New Hampshire, and I just want to clarify this because I think it's important, is that APRNs are required to hold both an RN license and an APRN license. There is not an NP license per se in New Hampshire. It's an APRN license that they have. But some of this alphabet soup and this language is part of what causes some of the problems in some of our statutes. That's, you guys know, for many professions. So in this case, we're just talking about the Nurse Practice Act and clarifying that when we're looking at those protections for people working in the nursing profession, that we're also looking and protecting those that are working in the advanced practice professions. Okay. Any questions?
All right, that's very good. Thank you. Are there questions? I have one that might sound silly. This seems pretty straightforward. Is it?
It's so basic.
Oh, okay.
It is. It's essential. So we've gone to the Board of Nursing and asked, do you think our APRNs would be covered? Can you guarantee that they'd be covered? And they can't tell us that they would be. So we have to do this. Now there's very similar language for physicians, and in that language it includes physicians and surgeons, right? But these guys are not physicians,
Right.
nor do they want to be called physicians.
So if I understand it correctly, then this bill is just bringing parity.
It's housekeeping.
Yeah,
It
okay.
truly isn't. It's probably bringing parity that was already intended, but not specifically
Not explicitly stated.
And all we're doing is preventing an issue down the line because of that vagueness.
Okay, thank you for that. Are there any other questions? Seeing none, appreciate you
Thank
being
you.
here. Brian Chinchillo is here as well. Good morning, sir. How are you?
Thank you, Mr. Chairman, Senators. I hope I'm not misinterpreting this. I did see this and it compelled me to testify. My name is Brian Chiricello, former Rockingham County Commissioner Chair.
Okay.
And dealt with a lot of nursing home nurses and staff. While I was a commissioner, we actually had 12 different contracts because we couldn't employ our own nurses, that we had traveling nurses. And the first thing I want to say is I don't begrudge anybody that wants to make more money. I understand that concept. However, one of the things that came up, and again, I apologize if I'm misinterpreting this, just please tell me, but we had many of those nurses with contracts that they had non-compete contracts. They could not work for the county for a number of years. And we all know that the shortage of nurses that we have doesn't make sense, that they couldn't. And there were, some cases where people wanted to work for the county. They were traveling nurses. They actually liked working there. Maybe some of them wanted to settle down and get employed by the county, but couldn't and had to leave, which was unfortunate. So again, if I'm misinterpreting this, I apologize. I'm hearing advanced registered nurses, which we did have too, but not as many. But thank you.
And you are supportive.
Yeah, I would
Yeah.
support that because I, with the shortage of nurses that we have, we shouldn't be limiting them where they can and cannot work. It's just not right.
Okay. All right. Are there any questions? All right. Thank you very
Thank you.
much. Appreciate it. Is there anyone else who would like to speak on Senate Bill 172? With that, I will close the hearing on Senate Bill 172 and remind everyone that we have committee again on Thursday, and then on March 4th, we'll have some more hearings. We'll exec all the FNs on that date and everything else on March 11th. With that, I'm going to adjourn the Committee on Commerce for the day. I don't need a motion.
I'll second it.
All right, he's seconding it. Is everyone in favor? Thank you. We are adjourned.